Hi, everybody. Welcome to the broadcast. And indeed, this is breaking news and big news. The Supreme Court to hear the first major abortion case since the new Supreme Court. I call it the Roberts II Supreme Court. This is with the addition of Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett. So you've got a expanded conservative bloc at the Supreme Court of the United States. You have a case coming out of Mississippi where Mississippi passed a law that basically, in essence, said after 15 weeks of the baby's life, unborn child's life, that abortions would be prohibited except in the case of the life of a mother, medical emergency, and fetal abnormality. Now, what's interesting about this, and we point this out in the brief that we filed in support of this, and that is this is really going to be a question of whether the stare decisis, that is Roe versus Wade, is still the framework upon which these cases should be reviewed. Now, Andy, stare decisis is only as good until the Supreme Court says it's not good anymore.
That's right. Stare decisis, of course, we know is a concept that says that cases that have been decided in a certain way based on certain facts and certain law should be decided the same way again and again. If our position is correct that Roe v. Wade was wrongly decided and the Casey case was wrongly decided, then stare decisis should not prevent the Supreme Court of the United States from following the law that was enacted in Mississippi. It should not. The Constitution should always trump stare decisis. In other words, what the Constitution says should always take precedence over what these man-made legal principles say.
C.C. Howell, senior counsel for the ACLJ, is with us also. And CC, give me your assessment of the significance. This is a big case. It's got big ramifications. What's your assessment of the significance here?
Well, it's very significant because the court, has said when a state's interest becomes compelling to protect the life of the baby. And they just picked an arbitrary point of viability. So this case is going to decide if the state can say that they're going to protect a baby before viability, and in this case, at 15 weeks.
What's interesting here, Harry, is from a policy standpoint, the time frame is moving back. This is kind of the left's great fear, is that the medical science, they're doing surgeries on these children in utero. So the medical science is outpacing the pro-abortionist desire to push the envelope.
Absolutely. And so in some respects, the pro-abortionists have been caught in a trap of their own making. They have suggested that abortion should be allowable up until the age of viability. But the age of viability is now coming down quite sharply. So that should mean that states should be allowed to impose restrictions on abortion to protect the life of the mother, the health of the fetus, and to protect humane treatment of human beings. And I think if you look at the facts in this particular case, the facts in this case support the state of Mississippi.
We're going to get into this in great detail. Walter Weber, senior counsel, wrote our brief. We filed a brief in this case because of your support of the ACLJ. And, of course, we'll be filing a merits brief as it goes to the Supreme Court of the United States for what's called a merits argument. They've granted certiorari. So if you're just joining us now, the Supreme Court has granted review in the most significant abortion-related case in at least a decade, as far as the possibility in dealing with Roe versus Wade. We'll get Walter Weber's take on this. We'll get our panel's take on what this means for the Supreme Court. When we come back, Van Bennett's going to talk about Title X funding. Your taxpayer dollars going to where? Abortion. We'll be back in a moment. So if you're just joining us, the Supreme Court of the United States has granted certiorari in a major case involving the constitutionality of an abortion and may well implicate Roe versus Wade. We'll be joined by Walter Weber, senior counsel for the ACLJ, who is the primary architect of our brief in just a moment. But before we do, that is not the only abortion-related news that's going on. Let me go to Washington, D.C., and our office there. Van Bennett, our Director of Governmental Affairs, Title X, up front and center. Van, what's happening on that front?
Yeah, of course, these issues come down on the same day, Jay. This is an issue that is going to be very familiar to our listeners. Title X funding. Look, this is one of those programs that Congress got it right when they wrote the statute that is supposed to provide for family planning programs. It says that none of the funds appropriated under this title shall be used in programs where abortion is a method of family planning. Very plain, Jay. Following the law would be very clear that entities like Planned Parenthood and other abortion providers should not be eligible for this funding. However, under the Obama administration, Planned Parenthood got an average of about $60 million under this program. President Trump's administration righted that wrong. They correctly applied the statute, made sure that abortion providers did not have access to these funds. But the Biden administration is set to change that back. Jay, today, actually in a matter of just a couple of hours here, we will be filing legal comments, get this, Jay, on behalf of 557,000 of our members, articulating what the law says and articulating what the Biden administration must do to comply.
I want
with
you
it.
to repeat. Now, folks, if you're listening anywhere in the country, if you're on Facebook or YouTube or Rumble or listening to the thousands of radio stations we're on, Sirius XM, whatever platform, aclj.org, right now share this with your friends because I want to talk about impact for a moment, and I'm going to have Than repeat that number because you're talking about a breathtaking amount of people responding. All right, so Than, restate that again. We're filing comments. I'm actually holding a copy of those comments right here. If you're watching us on television or a social media platform, you see it. There they are. These are our comments that are going in today on behalf of, Than?
557,000 ACLJ members, more than 500,000, Jay.
I mean, I want you to think about stadiums full of people that responded on this. So a huge thank you from all of us. That's how we mobilize and get action. You don't ignore 500,000 people on an issue like this. So your voice is going to be heard. Believe me, it will be heard. Walter Weber is senior counsel for the ACLJ. The case is called Dobbs versus Jackson's Women's Health. The petition for certiorari is granted. They limited it to the first question, which is restrictions on pre-viability, whether all the pre-viability prohibitions on elective abortions are unconstitutional. Walter, first of all, the significance of the case.
Sure. Well, this is huge because it's the first abortion case for the current slate of Supreme Court justices. We know the positions of a number of the justices who voted and spoken out on the issue before, but we have several justices who have not yet weighed in. And we're hoping, obviously, that they're going to follow the Constitution rather than the distortions of the Constitution that we've seen in the past over the abortion issue.
Okay, this is the issue. We talked about this, and I'm going to go back to Andy for a second here. You know, Roe versus Wade is deemed to be, quote, stare decisis. So let's first, Andy, define for our audience what that means legally.
All right, stare decisis is a judicial-made concept. It's a court-made concept. And what it says from English law to today is that cases that are based on the same facts and the same law should be decided in the same way. That is a principle of law that has been followed since the English common law was adopted in the United States. Cases that come up that have the same facts and the same law should be decided in the same way, and that gives stability to the law, and it gives us the ability to predict what's going to happen, and the law is not all over the place. But that doesn't trump the Constitution. The Constitution of the United States, first of all, says life, liberty, okay? And those are the kinds of things that we are looking at, that the Roe v. Wade and the Casey case should not trump the constitutional prohibition against the taking of life in the fashion that these abortion cases have permitted up to now.
Walter, do you think the framework of Roe versus Wade will be at issue here?
Definitely, because the reason this is a path-breaking case is that the prohibition on abortions goes after 15 weeks of gestation. The consensus is that viability starts at approximately 20 to 22 weeks of gestation, depending on how you measure it. So we're talking about 5 to 7 weeks before the baby would survive outside the womb. There's still a baby there, obviously.
Of course.
Heavily developed, but it'd be before the cutoff of viability. So if the Supreme Court were to say that viability is a hard and fast line and you can't ban abortions before that, as the lower courts have ruled in this case and other cases, then that's the end of the statute. They would have to modify Roe versus Wade or reinterpret its provisions in order to be able to uphold this law.
You know, there's been a lot of criticism, CC, of Roe versus Wade is not really a constitutional standard. Justice Blackmun's opinion there has been criticized very significantly, including by members of the current Supreme Court of the United States. But we're talking about what's deemed to be pre-viability. That is at 15 weeks. But what we have to also underscore, and Walter just touched on this, is regardless, we're talking about a human being.
Yes, that's right. We're talking about a baby, and the Supreme Court has repeatedly said that a state has a legitimate interest in protecting the life of a baby from the beginning of pregnancy. So we know the Supreme Court has admitted that life of a baby should be protected. But we're waiting on what is that compelling, when does it become a compelling interest? And that was just arbitrarily set at viability. And Justice O'Connor stated at one time that potential life is no less potential in the first weeks than it is after viability. So we are talking about a baby, potential life, and it needs to be protected. And Roe versus Wade, which, like you said, legal scholars and justices both have said it's just poorly written. And so we need to go back to what the Constitution states. There is no right to abortion in the Constitution, and hopefully this case is going to bring that issue to the forefront.
Harry, there's going to be a lot of pressure on the court when it comes to, there's going to be, I think Walter said in our pre-meeting, a flood of briefs saying you must uphold Roe versus Wade, you must uphold Roe versus Wade. But Roe versus Wade has been significantly criticized constitutionally by academics.
Absolutely. So essentially, the United States Supreme Court created a rule out of whole cloth. There is no constitutional foundation, at least in my opinion, for Roe v. Wade. And so even some distinguished scholars on the left have criticized the Supreme Court's decision-making in that particular case. But if you focus solely on the issue of viability, then the case ought to come down on this single question. What does the science say about viability? Now, importantly, we should note that pro-abortionists, they believe in the science and they believe in the law quite strongly, but only when it supports their position. Now the science is basically reducing the age of viability quite clearly, and the state of Mississippi can marshal a strong scientific case in support of its abortion restrictions. And so one particular point that they make in their brief is that any surgical abortion taking place after 15 weeks gestation carries inherent medical threats to the mother. The risk of a mother's death from abortion at 16 to 20 weeks gestation is 35 times more likely than at 8 weeks, and the relative risk of mortality increases by 38% for each additional week at higher gestation. Yep. So I think if we are really concerned about life, and if we're really concerned about the life of the mother, there is a clear and unmistakable statutory basis, scientific basis, which supports the Mississippi law.
Walter, how would you define a victory here? What does a win look like?
Anything that sends the case back and says either reversed or vacated would be a victory. Right. Because at this point, you got the lower courts basically striking it down. What I would love to see is for the court to make some – I mean, Roe versus Wade has so many problems with it. And I would love for them to recognize as an institution some of those problems. Like, for example, the way that babies are treated in abortion. We would never treat animals. I mean, the cruelty to animals statutes would forbid the kind of tearing limbs off, poisoning, right, slow suffocation, giving them an injection to kill the heartbeat. We'd never, ever consider doing that to a dog. The fact that we do that to human beings and act like that's a human right doesn't make a whole lot of sense, especially in a country that is founded on the idea of, the Declaration of Independence and human rights and equality.
Walter Weber, Senior Counsel for the ACLJ, architect of our brief that has now been granted review. The case has been granted review. We got a lot more on this. We're taking your calls, too. How big of an issue is the life issue for you? 1-800-684-3110. We talk about elections having consequences. Now you got a new Supreme Court. This is going to be a big test for that Supreme Court. We're going to talk about that. when we come back from the break. Also, more on this Title X situation. If you want to support the work of the ACLJ, go to aclj.org. That's how we do it. That's how we file these briefs. That's how we bring you this broadcast each and every day. Back with more in just a moment. Hey, welcome back. If you're just joining us, the Supreme Court of the United States has granted review in, I think, the most significant abortion-related case, Roe versus Wade type of case, maybe in our lifetime, because you have a new Supreme Court, a different Supreme Court, a Supreme Court decision that's probably going to come down to two justices, Gorsuch and Kavanaugh. That's any kind of our speculation, but we don't know where Gorsuch and Kavanaugh are on these issues yet. We know their judicial philosophy, but they're going to play a key role here because I think Thomas, Alito, Comey, Barrett, I think, we don't know Justice Barrett's judicial philosophy on this yet, but she follows a Scalia-type model, so I would expect that she would say this framework's no good. But the other two, we don't know yet.
Yeah,
we're going to find out.
Yeah, we're going to find out very soon. I think that one of the true conservative on the court, in my opinion, of all conservatives, the true conservative on the court is Clarence Thomas.
Yes, I put Alito right with him. Close.
Alito, but yeah. Justice Thomas impresses me and has always impressed me so very, very much as being a follower of the Constitution and a textualist, and we know what his position on this is. The
other two, I don't know.
The other two, we have not seen them yet.
So, Cece, when you look at the case, I mean, the argument they're going to come back, and Walter said they're going to just pile on this, and they're going to say this is a pre-viability case. Thus, this is ridiculous. It's not post-viability where it's a different issue or the standards of review are different. This is pre-viability. That's what the pro-abortionists are going to be arguing.
Right. And so the point still remains that viability point is an arbitrary point that the court picked of when a state's interest in protecting the health and life of the mother and the baby becomes compelling. So that's really, I think, what's at issue is obviously, like Justice O'Connor said, potential life is no less potential in the first few weeks than it is after viability. And so if we truly believe that the state has a compelling interest to protect the life and health of the mother and the baby, then we need to take a very good look at when that begins. And it, of course, is before viability. The baby can feel pain. The baby is fully, really formed physically at 15 weeks and can sense things outside the womb. So there is a point where the state obviously can protect the health and life of the mother and the baby. And clearly that needs to be determined before viability.
Let's go to Chris, who's calling from Nevada. He's on line 2. Hi, Chris. Welcome to the broadcast. You're on the air.
Hi, thank you. Since a baby can't take care of itself, whether it's at 1 week or 9 months, can you please define viability for me?
Well, the way the court has defined viability is that based on medical science. In other words, could the child survive outside the womb? See, that's that's kind of been the legal definition of a medical term of art, and the viability generally people are saying, doctors will say, is around 20 or 22 weeks.
That's right. And babies have been born early on and have survived. So basically viability is they're able to breathe and live. Obviously, someone's going to have to take care of them, just like the caller stated, for, almost the first, 10, 12 years of their life. Parents need to be taking care of their children. But it's when the baby can actually survive outside of the womb.
So I've always questioned this, though, Harry, and that is that even the proper standard? If we believe that the life of the unborn child is a life from the moment of conception, and a law is written that says, okay, look, hey, if you got life of the mother at risk, those kind of things, that's one thing. But if not, does the value of that human life change by the week?
No, I think the
courts have said it does, but I mean, is that really good policy?
Probably not. So I think the key quintessential issue is the following. Does the state have a compelling interest in protecting the life and the health of both the mother and the fetus? And I think if we follow the science and if we follow our belief in protecting human life? The answer, I think, is clearly yes. And so here, the state of Mississippi is prepared to take affirmative steps to protect both the mother's life and the life of the child. And I think you cannot deny the state's interest in doing that. I think the abortionists, the people that clearly support abortion, they are prepared to allow an abortion to take place after the child is indeed born alive. And so if you go back to the memorable words of Governor Northam in Virginia, you allow the child to be born, you make the child comfortable, and then you decide whether or not the child is entitled to live. Clearly, beyond question, at that particular point, no one ought to be willing to deny the right of that child to live. But progressives do not, generally speaking, believe in life. They believe in the notion of progress. And if you go back and you look at the history of the eugenics movement in the United States, it verges on a form of genocide which was aimed at shrinking the population of so-called unfit and unemployable individuals. And I think the Mississippi law stands in stark contrast to that move by progressives.
You know, Governor Northam's comments, and you were shaking your head.
I remember
those. So reprehensible, but yet so typical of those that are in favor of an unrestricted right to abortion.
Yeah, follow the science until it doesn't follow the left's narrative, as someone said on YouTube, and our producer gave us. But I remember that Northam made those statements. In other words, have the child, make it comfortable, and then decide whether it's outside the womb and it's there, a living, breathing, real human being, and then decide, let's be real candid, Jay, whether to kill it or not. That's exactly what that is.
No.
And that's what's known as, and has always been known as, infanticide. And he made those statements.
No, it's heart-wrenching. All right, I want to go up to Washington, D.C. again. Let's talk about this Title X abortion issue. So what is going to happen here, and what can be done, Than? What's the situation?
Yeah, the Biden administration, Jay, has filed this rule, and if it goes into full effect, it would again make these funds available to Planned Parenthood for abortion services. It's that common shell game that they play, an accounting game where they wouldn't use it directly for abortion, but it would free up their own dollars for it. Jay, we are filing those comments. I want to say this again on behalf of more than 500,000 ACLJ members opposing it. And look, I don't have any great confidence that the Biden administration is going to do the right thing, but here's why we do it anyway, Jay. Those 557,000 members, they're not going anywhere. They're going to continue to speak, they're going to continue to advocate, and they're going to continue to vote. So while there may be some setbacks in the short term, Jay, this has always been the long game for us. And in the end, Jay, after we play the long game, we're going to win on this one in the end.
You know, the states have the right to make these decisions, in my opinion.
Yes.
It's left to the states. And Mississippi's House Bill 1510 had some very smart, rather reasonable scientific evidence to support it. They didn't just pull that out of whole cloth. And when she says draconian state laws, I read House Bill 1510 of the Mississippi legislature, and it's not draconian. It makes sense. The reasoning behind the law is, one, there are inherent medical threats to the mother in abortions less than 8 weeks gestation. Two, science supports the fact that the preborn child has a conscious awareness of pain at 14 to 20 weeks gestation. And three, the act regulates inhumane procedures even beyond a stage where the humanity of the preborn child is undeniable. What is draconian about that reasoning?
It's because
it makes sense.
Yeah, it's because it goes against their entire narrative. Let's go to Jen calling from Colorado. Last call of the day. Jen, you're on the air.
Hi, thank you for taking my call.
Sure.
I have a question. Is this normal for the Supreme Court to kind of decline hearing so many cases? And also, if they decide to hear a case, is it normal for them only to hear or to choose to hear kind of one topic of that?
This was an unusual one because it bounced up and back to the Supreme Court a lot. I mean, it was up and back and up and back at the Supreme Court in conference and out of conference and back in conference, I think 14 times. I mean, I don't think I'm exaggerating. I think it was 10 to 14 times. And finally, they agreed to hear it. Now, you had a change of personnel. That could be part of it. And yes, they're very picky on what cases they take. Really picky on what cases they take. And in that context, you have to understand the nature of what we're dealing with. So yes, They are picky on what they take. They do understand that the issues are significant here. And I think at the end of the day that this is a great opportunity for a new Supreme Court, because it's like the Roberts 2.0 court, Harry. I mean, it's going to be the first shot at where they are on this.
Absolutely. And the fact that the United States Supreme Court is so picky about taking cases, I think increases the importance of this particular case and this particular decision.
Pete Williams from NBC News, a friend of ours, said, I think I counted last week 17 times they've discussed this case. This is what he said. And it was the 18th one that was the breakthrough. I don't think we have the actual sound of that, but that is what he said. So I thought it was 14, but now it looks like it was 18. Anyways, there you have it. We're going to be filing a brief, which means your support of the American Center for Law and Justice is critical. We get you this information on radio, TV, social media platforms. We also take action. We'll be filing a brief on the merits. We already filed one on the petition for certiorari. That was granted. So now comes the merits phase, the big phase. Can we see an overturning of Roe versus Wade? Your support for the ACLJ makes a critical difference. Go to aclj.org and support the work of the ACLJ, aclj.org.